Bill Fassett. Dr. Fassett is Professor Emeritus of Pharmacy Law and Ethics at Washington State University in Spokane. His bachelor's in pharmacy is from University of Washington. His MBA is from University of Puget Sound, and his PhD is from UW. Go Dogs. He practiced long-term care and community pharmacy prior to and during his academic career, which began in 1980 at UW, continued from 1994 to 1999 at Drake University, where he was pharmacy practice department chair, and completed at WSU from 1999 to 2014, where he served as dean and later professor. Welcome, Dr. Fassett.
Thank you. It's a pleasure. I didn't pay close attention when they scheduled this. I suddenly dawned on me that 3 o'clock is my nap time. So the goal will be for me to stay awake during my own presentation. By the way, the Washington State University has joined the throng of leading forward-thinking progressive universities, including Oregon and Reed and a few other well-known liberal colleges. I will no longer be known as Professor Emeritus. We are adopting the term Professor Emerit to be on the forefront of non-gender specific titles. So from now on, I will be Professor Emerit. I was explaining to somebody the other day, it came from the Latin word a, meaning e, meaning out of, and merit, of course, being worthwhile. So when you're no longer worthwhile, you get to be a merit. To the person, if you're still on, who was online, that asked the question about the tax deductibility of student loans, any of the federal reductions, when they do that, they are in fact tax exempt. Some of the state exemptions, reductions will also be tax exempt if you work in one of the federally shortage areas in certain professions. So, but as they say, check with your tax expert on the deductibility of any taxes. I always think the starting point is to presume you're going to have to pay it, then you'll always be pleasantly surprised if otherwise. So today is
Bill Fassett.
an opportunity to laugh at the sadness of others and to learn from their mistakes. And let's see, where's my advance? I think I'm clicking the right thing. Oh, there we go. So I tried to limit it to 3 things because I could remember 3 things. And 2 of them relate, not surprisingly, to COVID. One of the questions is, what are the consequences of falsifying vaccination documents? Second question is, what is serva? And the third deals with kind of an interesting recent circumstance that I was asked to look into. It has to do with this policy of scheduling meds for people. And as you know now that Amazon and AccuPack and PillPack and ReguPack and QuickPack and probably Costco, Target, and all the other great retailers are going to get into the act. What are some of the issues that might evolve in that? I'll be interested if any of you are involved in med scheduling. We'll have a little discussion of that. So I have 2 types of self-assessment questions. This is the more traditional type where we ask some pre-questions and let you think about them for a minute, and we'll come back at the end and answer them. And then, of course, we have some lecture panda questions along the way. So the first pre-question is, and we're not going to take show of hands, but you can just ask yourself, what is this vaccination record card? Mine's all folded up and stapled now because It was designed by the federal government so that it couldn't possibly fit in a wallet. But is it a piece of federal property? Is it required if your pharmacy, do you have to give it out if you're getting reimbursed under the federal pharmacy program? Is it something that's required by the Department of Health in some way? Or is it all of the above? Second question we're going to look at today is serva. Serva stands for shoulder injury related to vaccine administration. And is it very rare? Is it compensable under the Vaccine Injury Act? And is it simply an unavoidable result? It's sort of the luck of the draw that if you get a patient with bad genes, they're going to have a reaction, but most people it's not going to be an issue. And then finally, we're going to talk about the packaging. What are the reasonable expectations of a patient who comes to somebody like AccuPack or PillPack or your pharmacy that proposes to schedule their meds? Now, I recognize that there are two approaches. One is to schedule my meds, which is getting all of your meds put together to arrive on the same day. And that's not exactly what I'm talking about. I'm talking about the other one where you essay that what you're going to do is you're going to put the things together in little envelopes that when they open up the envelope on Monday morning for Monday, that's got the meds they're supposed to take at that time, okay? So that's what I'm really talking about. Is it reasonable that that should be free, or is it reasonable to charge for that? Second, unless it's clearly understood otherwise, would a patient normally think that everything they're supposed to take is actually in that package? And third, is it reasonable that the patient who goes to the doctor and the doc says, I want you to stop taking that, should they have some responsibility to call the pharmacy, or is that just up to the doctor and the pharmacy? So those are some of the issues that seem to be emerging. So let's jump right into other people's problems. So one of the first things that happened was a group of health professionals throughout the country during COVID. I used to think the only thing that really brought out the worst in us was to have somebody die and leave the farm to three brothers. Nothing seems to bring out the worst in a family like the death of somebody who leaves you money to fight over. But I now think that somehow COVID really brought out the worst and the best in our professions. And I cannot believe how really, really stupid people acted in response to what should have been settled science. Until I started reading about what happened with the 1917, 18, 19 flu epidemic, and all the same responses happened. So human beings haven't evolved that much. Now, one of the more interesting ones, because that's come to actual fruition, is the jailing of a Wisconsin pharmacist for 3 years for product tampering. He somehow decided that these mRNA vaccines were going to adversely modify people's genetics. So I apparently didn't learn what mRNA does and how it works. Sort of like the pharmacists that a few pharmacists continue to think that birth control pills will lead to an abortion. They just failed that part of pharmacology somewhere along the line. They don't actually understand how mRNA works. Well, anyway, he thought this would probably be dangerous. So, and he didn't like being involved in the whole thing and being ordered around by the crazy Wisconsin governor or whoever. So he just decided to deliberately leave out the Moderna vaccine. Now, this was at a time when they didn't realize that the Moderna vaccine was actually more stable than it was. But it led to having them throw out a whole bunch of vaccine at a time that it was in very short supply. Well, he was tried and convicted under federal anti-tampering law. We're going to talk about that law. They really kind of threw the book at him. He's lucky that he only got 3 years. And then my next one was the trial has not happened yet, so we don't know what's going to be the sentence for this guy, but he decided he could make money by selling COVID ID cards online, and he sold about 125 of them, averaging about $10 a card. Now, it turns out that was, if he had sold 90 of them at $10 a card, he would have been a lot better off. Because as we'll discover, there's a dollar volume limit in the federal law. So he was charged with 12 counts of theft of government property with an aggregate value exceeding $1,000. And we'll explain why the federal charges were for this violation as opposed to what seemed to me to be simple, straightforward forgery and fraud. At any rate, he faces up to 10 years in jail if he's convicted. So let's talk about these two cases and what the statutes are. The Federal Anti-Tampering Act, I was going to ask, how many of you have been around long enough that you took your board exam in this room? Anybody? I knew there'd be at least a couple. Yeah. I had my internship all done when I graduated from pharmacy school, so I took mine in College Hall in Pullman. But the folks that took the fall exams, this is where they used to be. Okay. Which shows just how old this auditorium really is. Well, in 1983, the Tylenol tampering, if you remember, who remembers what the product was in the state of Washington, in Olympia? Pardon? No, that was in Chicago. What was it in Washington? Anybody remember? Sudafed. Stella Nickel. Still in federal prison. She keeps trying to get out, and they keep denying her parole. Anyway, Stella Nickel was the Chicago lady. The one here in Washington was a guy who killed his wife and then tried copycat based on and spread the Sudafed with, these were the Sudafed capsules, put cyanide in them and spread them around the area. At any rate, so obviously that's a horrible thing to do, is to put cyanide in Sudafed or Tylenol. And the government reacted with up to 20, well, actually up to life in prison if you kill somebody. Well, we'll see in a minute what the definition of tampering is. But even attempted tampering is up to 10 years. And if it causes serious bodily injury, it's up to 20 years in prison and a fine. Then another related statute to these two cases is public money, property, or records, and this is section 18 USC. 18 USC is the section of the federal code that deals with all sorts of crimes. So if somebody talks about you did an 18 USC thing, you're talking about some type of federal criminal law. But if you embezzle, steal, purloin, or without authority sell, convey, or dispose of record, voucher, money, or thing of value, maybe classified information being flushed down toilets would qualify here, I don't know. Shall be fined or imprisoned not more than 10 years or both, but if the value does not exceed the sum of $1,000, there's a 1-year limit. Well, that last 25 cards really did this guy in. So for the guy in Wisconsin, he got nailed by tampering. Now, the definition of tampering is maliciously causing or attempting to cause injury or death by adulterating a food, drug, or cosmetic or other substance. Okay. But you have to look at, always have to look at what the definitions are. Now, we think of malicious as just being mean-spirited, but in fact, malicious under federal law just means that it's wrongful, that was intentionally done, that is, you didn't do it accidentally, and without legal justification. So you don't have to actually be evil in your heart to be malicious. You just have to do something wrong and do it on purpose, or intend to do what you did. You do not have to intend injury. You only have to intend to do what was illegal. And the word attempt is to take an action that, if you succeeded at it, would constitute the crime. We normally think, well, you know, I attempted to eat the cookie. We mean I must have intended to eat the cookie, but intent is different from attempt. And so in this case, he may have thought, this pharmacist in Wisconsin may have thought, if I destroy this Moderna vaccine, I'm actually preventing people from having their genes rearranged. Okay? He may not have actually intended to hurt anybody, but he did intend to commit a malicious act that, in the minds of the jury that convicted him, could have led to injury to a person. So the attempt could have caused injury, and that's how they got him. And adulteration is contaminated, stored, you know, we used to have that. What's the difference between adulteration and misbranding? Blah, blah, blah. Okay, well, anyway, adulteration really requires that the product itself somehow be affected. So it's contaminated, stored in insanitary conditions, or the facilities or controls for processing, packaging, or storing it, holding it, don't conform to those that are needed to maintain its strength and purity. Now, in a case that Julie and I both are aware of, a pharmacist in the state of Washington, who was actually one of my former students, had a drug problem, and he was taking fentanyl patches out of the boxes in the pharmacy where he worked, and then taping the boxes back up and putting them back in the safe. And he is in federal prison. He was convicted under this statute of product tampering. And the prosecutors, the defense argued, he didn't affect the product at all. He just took it out of the box. You know, charge him with theft, if you will. Charge him with diversion, but don't charge him with tampering. And the prosecutors convinced the judge in this case that no, tampering, if somebody was given a prescription and the pharmacy filled it without opening it, and that led them to go without their drug, they would be harmed. And when the judge ruled, as I remember the case, when the judge ruled that that was the way he was going to define the case for the jury, at that point, the lawyers for the pharmacist said, you'd better settle for the minimum term you can get, and that's what he did. It actually failed on appeal, but that's what happened. So the federal prosecutors use this statute like a bludgeon very often to get people to plead to a lesser offense. Although in this particular Wisconsin case, there's no question what he did damaged the product, and it was definitely product tampering. Another issue that arose in the case of selling those cards was healthcare fraud. And healthcare fraud is primarily not a criminal act. There is criminal healthcare fraud, but most healthcare fraud is resolved with civil lawsuits and the federal government extracting civil fines and clawing back payment for claims submitted. And we all know these, but just as a good reminder, in your daily practice, in your daily practice, you do not want to bill for services that you haven't rendered or products that you didn't deliver. So there's a lot. I mean, the last few years, there have been many pharmacies have been in trouble over the last few years where they decided they could get wealthy, especially during COVID. We're not going to talk about this case in detail, but during COVID, there was they suspended some of the requirements for getting approval for certain types of products, including HIV meds and other things. They didn't require they eliminated prior authorization for Medicare and Medicaid. They speeded up payment and so on. And so pharmacists filed a whole bunch of claims for drugs in these categories that weren't ever delivered. And they're all now going to court. And on the federal fraud claims, they're all having to reimburse millions and millions of dollars from the federal government. Misrepresenting services rendered or provided. Where that has hit pharmacists, retail pharmacists the most, and again, it usually doesn't hit the individual pharmacist, it hits their employer who submits the claims. But one of them that several of our chains got involved in was billing for a tablet when a capsule was dispensed because the reimbursement for the tablet didn't have a MAC and the capsule did. Well, they're the same drug, yeah, but they're not the same product. Or upbilling, or the other one is billing for a product using the NDC for the 100 tablet bottle when you bought 1,000. Very common fraud claims. They usually are resolved during audits. But the reason there's not an Eckert Drugs anymore is because Eckert was the first company to get nailed on these unretracted WEOs. How many have had to deal with a WEO in their life? You know what a WEO is? What do you call them? We had patient had 30 tablets, we only had 28, we owe them 2. But now how many people have dealt with WEOs in their life? Yeah. Well, if you never go back and prove that you gave them the other 2 tablets, or you never go back and reverse that claim, you've committed healthcare fraud. And Eckert got nailed by, they just didn't have any system throughout any of their stores to make sure that they could show that they had ever, and the federal government hit them for something like 100,000 prescriptions that claims, and the fine is 10,000 per claim, so it adds up. Falsifying records to meet conditions of participation, billing for unnecessary services. That's been the other big fraud claim in the last 3 or 4 years, is the wonders of compounded pain creams. Compounded pain creams, they work so much better than the drugs, and they get prescribed for, well, they don't get prescribed for Medicare and Medicaid because they've got controls. What do they get prescribed for? Car accidents, labored industries. And now we're seeing pharmacies that got really big into filling car accident claims being sued by the insurers for fraud. And part of the complication was that in order to get those claims from physicians who dealt with on-the-job injury or who dealt with car accidents a lot, the pharmacies were providing kickbacks to the prescribers. So all of those are sort of in there that affect the possibility of these cases. Now, the reason that forgery might not have been alleged in the case in Chicago. The reason they charged him with theft of government property rather than forgery is that there really isn't a federal forgery law. There's fraud laws and so on, but forgery is primarily a state crime. And so when the feds prosecuted the guy in Chicago, they couldn't make a federal charge of forgery. But forgery in the state of Washington is if you do it with intent to injure or defraud. That is, if you intend for a document to represent something that will tell a false story to somebody else and therefore defraud them, you falsely make, complete, or alter a written instrument, or possess, or utter, or offer, or dispose of, or puts off as true. This is for language from the statute. A written instrument for which he knows to be forged. Now, the thing about forgery, it only relates to written instruments. So it doesn't relate to anything that's electronic. But I've had requests over the years, not so much, probably not so much anymore, but in the early days, when people got reimbursed after they'd pay you and then they'd get reimbursed by the insurance company. Some of you remember that when they paid us our actual cash fee, whatever our normal fee was, and then they submitted their receipt to the. I had offers of people asking me for a slightly elevated receipt, you know, to cover that so that the doctor's visit could get rolled into the price of the prescription. They offered to pay me $1 for filling that out or something like that. Well, had I done that, I would have been forging. I would have committed forgery in the state. But it sounds like such a simple little thing and such a mild offense. But every one of those kinds of requests is actual forgery. And so, just not too long ago, a physician's assistant was charged with forgery because they were false for two things they were doing. They were falsely certifying, this is probably about 5 years ago now because the laws have changed, but they were falsely certifying that people were medically qualified to get pot for a fee. And the other thing they were doing was falsely certifying for a $25 fee, writing out the form to get a disabled parking permit. And they were convicted of forgery in the state of Washington. So somewhere along the line, people get the idea it's a minor thing. I'll just do this as a favor to a friend, but it can get into problems because it's a Class C felony punishable by up to 5 years in prison. And then the other factor that can relate to our activities is unprofessional conduct. And I've always enjoyed the fact that we still punish people for something called moral turpitude. I used to want to say turpentine, and I still want to say it. Moral turpentine, dishonesty or corruption relating to the practice of the profession. Well, moral turpitude is a very ancient term, and what it means is it doesn't really mean anything. It means doing something wrong. It's nothing special about moral turpitude. Immoral turpitude is just as wrong as moral turpitude. At any rate, but dishonesty or corruption are examples of turpitude. Violation of statutes or rules regulating the profession. And this is just a selected list for a particular purpose. Violation of rules established by a health agency, misrepresentation or fraud, and the Uniform Disciplinary Act applies to anybody who gets a credential from the Department of Health. So as it turns out, it's important to our next case, that includes EMTs, first responders. It also includes, in case they have forgotten it. For the last 2 years, it also includes your pharmacy assistants. So ever since pharmacy assistants now have to pay their separate individual license and registration, they come under the disciplinary act just like you do and just like the technicians do, like technicians and pharmacists do. So a genius former coug, well, I guess they're always a coug, but turns out this is a coug, who was at one time SAFA president. So he started off with a good heart. But somewhere along the line, during COVID-19, this pharmacist was persuaded by the EMTs in East Wenatchee, who were really upset about being forced to get vaccinated in order to treat people during COVID, and thought that King Inslee was exceeding his powers, and they didn't want to get vaccinated, but they had to get vaccinated. They persuaded him to take the vaccine, put it in the syringe, squirt it into a garbage can, and fill out a COVID vaccine card, as well as the associated vaccination record and claim form in the pharmacy records, saying that he had actually administered the drug in one of their specified deltoid muscles. So we know that firefighters were provided fraudulent records according to the published report. Now, this is all according to published reports in the Wenatchee World. The firefighters, somebody blew the whistle on them to Douglas County, and Douglas County investigated, and they ended up being fired or resigning. Because guess what? They're covered by RCW 18.130.180, the EMTs are, and the paramedics. So the administration records were also falsified because, he wasn't going to pay for the vaccine, right? Somebody was going to pay for the vaccine that he threw away. So as of March 9th, the Wenatchee World reported that Katie Pope at Pequak had confirmed that the investigation had been completed and was under legal review. So our first set of legal considerations are, put yourself in the shoes of an assistant attorney general advising the Board of Pharmacy, or Pequak, what they should charge the pharmacist with. And we've got 4 questions on the Panda. If we'll go through them one at a time. So the first question is, based on published news reports, I've changed this stuff on Panda to be a little more legally correct. Based on published news reports, did a pharmacist in East Wenatchee tamper with a consumer product? And true lawyer answer is not ever yes or no, probably or probably not. So give me a lawyer answer of probably or probably not. Okay. We're having a race between probably, uh-oh. Okay. Well, that may be where the lawyers settle on this one. I think the best answer is probably not. And the reason is that he did not adulterate the product. That's the key element here. He did a lot of things wrong with the product, but he did not adulterate it. He just didn't give it where it was supposed to be given. So I don't think they're going to be able to charge him with tampering. Okay, so let's go to the next one. Based on published reports, did the pharmacist Eastman actually cause the employer to submit false claims to the federal government? I got three choices. One is probably. Second is probably not. The third is probably, but the good news is the employer also probably reversed any claims after it fired this pharmacist. And yeah, so we've got about a third saying probably and about a third saying probably, but they are willing to give the pharmacy credit for having figured out that they need to reverse those claims. Okay. Your experience may vary. Individual experiences with individual employers may vary as to how you would, how much credit you'd be willing to give to your employer. Okay, third one. Did the pharmacist in Eastwood actually commit forgery? Okay. I think we're anonymous on this one, or unanimous on this one. Yeah. Yeah, no question. Under the false record, did it on purpose with the intent to defraud, to persuade people something that wasn't actually there. Okay, and the last question. Okay, based on published news reports, a pharmacist in Eastwood actually could be charged with unprofessional conduct based on moral turpentine, violated state, federal law or regulation, violation of rules established by a health agency, misrepresentation or fraud, all of the above, or none of the above, because the vaccine mandate was not a law, it was just Governor Inslee's pipe dream. Yeah. And looks like the overwhelming majority agree that probably this, I don't know what you call a trifecta plus one. Huh? A quadrifecta. He committed a quadrifecta here, yeah. And it's really sad. I've been told that if you figure out who the pharmacist is and look at their LinkedIn profile, they are now looking for a job in pharmaceutical sales or lobbying. No, I'm sorry. That's fine. Anyway, so, but it is sad because, you know, at the time, I'm willing to bet that none of these considerations that what I'm doing is going to get me in a whole lot of trouble, that there's somehow this idea that this is just between me and the firefighters, and I'm not really hurting anybody, and I hate this whole system anyway. Because I just still find it hard to believe that if you just want to get out of pharmacy, you just don't leave. But, okay. All right. So this is not going to be laughing at other people's problems. This is going to be something which I think is we're not paying enough attention to as a profession. How many of us are, in fact, and I'll count myself in, how many of us are immunizers? Okay. So serva is shoulder injury related to vaccine administration. And fortunately, it doesn't always last forever, but it is shoulder pain, limited range of motion after a vaccine injection intended for IM administration in the upper arm. It is generally the current belief and evaluation of the cause of serva is that it is iatrogenic. It is caused by the improper administration of the vaccine, not in the muscle, but in the joint space. It's not a nerve injury, it's an inflammatory reaction. And it's because the drug gets outside of the muscle. And one of the things that I've seen currently in recommendations, and the very huge volume of immunizations done under COVID has probably brought some of these to attention, suggesting that, and I'm planning to incorporate this in my own practice. If you have somebody who doesn't have a whole lot of deltoid, that you might go posterior. So you get an extra millimeter or two of muscle if you go slightly posterior rather than just lateral. But 90 degrees to the muscle mass. The other is using a proper needle size so that you don't go through the muscle and into the space. Even if you don't hit a bone, you can still go through the muscle and into the space. And I volunteered to give vaccines during COVID and probably did about 1,000 of them. One of the challenges of these mass vaccination clinics was that they didn't always have the right size needle. And and I had 2 patients where they did have the right size needle. And I did what every brave pharmacist does. I'm going to refer them to a nurse. If the nurse is willing to shoot it, that nurse might be better at keeping, but if I had a little teeny tiny lady with a very teeny tiny muscle and they still wanted me to use a full length needle and couldn't give me the short one, I just turfed it, to be honest, because I wasn't counting on my ability to hold that needle short. Get back here. So quite a number of years ago, they established the Federal Vaccine Injury Compensation Plan. And the manufacturers contribute, I think it's a nickel per dose. So it's for 5 cents for every dose goes into this federal trust fund to compensate people who get complications from vaccines that are otherwise, or that are commonly caused by vaccination. So that no individual patient who's getting vaccinated for the good of the entire population, for the most part, should have to go uncompensated. And the plan does 2 things, and the lawyers that specialize in it love it because the plan pays the lawyer fee. So if you have a claim, you don't have to pay any lawyer bill. That will be paid, and the lawyers get paid even if the claim is denied. They get paid for their time. And serva was fairly uncommon until 2017 or so, with 53% of all the claims by 2019 were for serva. Of all the claims reported to the VICP, 53% by 2019 were serva. Now, we won't know till about 6 months from now what the 2020 claims were, but I'm guessing that in 2020, 2021, 2022, those claims have gone even higher. Turns out the median award to a patient for claim paid to the patient is $72,000. Their estimates are that if those claims were handled in our regular court system, the average claim would be about $30,000. So the awards are pretty generous. And about 120 million were paid out over that 2 years for serva claims alone. And not surprisingly now, because pharmacies are now the #1 source of vaccinations, we're also the #1 source of serva. So how do we avoid it? Because it really is, if one of your patients develops serva after you've given them an immunization, it really probably is the result of an error on your part. So one physician who studied this issue and teaches at one of the medical schools says, you know, you just have to learn to feel where the needle is. You feel it, quote, pop through the skin. The fat is like butter, the muscle is like steak. So if it feels like you're injecting into butter instead of steak, his advice is, don't inject the drug, pull out the needle and do a second shot. The fact that you've got it in the wrong place doesn't mean it's a good idea to inject the drug, because the needle isn't causing the problem, right? It's the drug. So if you end up in the wrong spot, you have to have the presence of mind and the closeness of attention to say, embarrassing, but I'm going to pull this out. You tell the patient, sorry, it bounced. We'll try again. Pharmacies are at a disadvantage because the setting that we operate in very often encourages people to come improperly dressed for an immunization. And so they do. When they pull their, when they pull their shirt down, all that leaves for you to shoot into is the joint. So if you can get them to pull their shirt up, it's okay if they can't get the sleeve all the way up, because you're not going to go where the sleeve is. It's the other situation that you have to avoid. And hopefully, yeah, we have a question? I have not, but for pediatrics, as how many do pediatric stuff? Little kids, because they do the vastus lateralis in little kids. They do it here. I know no reason why the drug wouldn't be useful, but it's indicated for injection in the upper arm. Jenny, you probably know more about this than I. Yeah, there's muscle there. You just have to.
Well, it's actually using a 1-inch needle is indicated in kids in that age, or even a 5/8 needle into the deltoid muscle in that area. You need to engage the parents so that they don't wiggle, but there is muscle. They lift their arms up, so there's muscle there. And I think there is some absorption differences when you use different anatomical sites. And it's difficult when you get older kids to start pulling down their pants for administering medications, especially in public settings. So I think when appropriate, use the deltoid muscle still, but an appropriate size needle.
Yeah, and there were a couple cases where, frankly, given that I was on my 300th shot, 400th shot in the career, and I had a nurse next to me who'd given 20,000, that I had no problem in saying, I'm going to turf this one. And if I were in a pharmacy and the person wasn't prepared to give me adequate access to their deltoid, I would ask them to go to their primary care provider. What was it? Yeah.
The question was regarding the VA system and them not reporting to the state registry. They did eventually import over, gives the state some access to that. So if you're on our town hall calls on Wednesdays, you see the numbers are a little bit higher and they've added in the VA numbers and that. But I agree. I think there's a big need for a national reporting system for immunizations. And we should expect that TRICARE and the VA and other systems do report into that. And right now, you're right, there is a lack of that.
The rule that we adopted at the clinics that I volunteered at was if they came in and told us this was their second shot, didn't have their card, we gave them another card, recorded that we gave them the vaccine, and they can put the two cards together. There's no contraindication to a second shot. Yeah. Yeah, well, they're victimized by having had $10 billion to give to Cerner to get their computer system, to replace the computer system that worked very, very well that they developed at the VA over the years. So at any rate, the other challenge here that turns out to be even maybe equally problematic is that when somebody does get serva, they file a claim with the VICP, and they submit their claim, they send in the records, the VICP gets the records from the pharmacy or from the doctor's office, and then somebody administratively looks at the claim. And in a fair percentage, a not uncommon percentage of the cases, the patient is claiming that they have an injury to their left shoulder, but the pharmacy record shows that the shot was given in the right arm, or vice versa. And this is definitely a pharmacy problem. This has now been identified by people that look at these records as pharmacy records are much more likely to be incorrect than records from physicians' offices. And it appears the reason is how pharmacy bills claims versus how physicians bill claims. Physicians do what they do. They write it down and somebody else in the office records the claim and sends it in later. Pharmacies, I'm told by the folks that do this, that in most of your pharmacies, when the person requests the vaccine, they fill out the form and you have to process all that information in the claim at the time you get it approved for payment. So you have a claim that's produced that includes the location of the injection before the injection is actually given. And if anything changes in the little room, it doesn't get recorded. And so if those don't match, then the administrative personnel in the VICP just deny the claim. And then the next step is anywhere from a 1 to 3 year process where the person gets a lawyer to file a lawsuit in the Court of Federal Claims to get a special master to adjudicate the claim. And so the problems arise from pre-completion of vaccine records, which for pharmacy seems to be really common. 2 vaccines administered at the same time, and dispute over whether they both went in the same arm or they went in different arms, or which vaccine went in which arm, and so on. And the failure to record at the time of vaccination. And I will tell you that when I was in the vaccine clinics, mass vaccine clinics, they had 2 people assigned simply to make sure that the vaccinators recorded the arm. That's the easiest thing to forget to do. You know, when you're doing everything else and you're talking to the patient and you're cleaning up the blood off their shirt and whatever, it's easy to forget to write that down. So, but this record is really critical. So here's the most recent serva case. I write a monthly newsletter for the American Society for Pharmacy Law. And in the last year, I have summarized about 20 of these serva cases, all of them involving pharmacies. This is the most recent one. And look at the dates here. 2017 was a flu shot. They filed a claim in early 2018. The computer record showed that it was the left arm, but the right arm was injured. Finally got resolved in February of 2022. And what they showed was that the written consent form showed that the pharmacist had written LA, had circled LA and RA, and crossed one out, and crossed out LA. But the computer record, which was filled out before the shot was given, was never changed. And the patient filed an affidavit that, yes, I originally went to the pharmacist and said, well, which arm should I get it in? And the pharmacist said, you know, which arm do you eat ice cream with? Get it in the other. I mean, that's my rule. Don't mess with the arm that you eat ice cream with. How many think that it really matters whether they get in the dominant or non-dominant arm? As far as I know, it doesn't. There's no evidence that it really matters. Yeah. Yeah. But probably it's not critical. Anyway, but people ask you for an answer, and it's better to give them one than to say it's up to you. Anyway, she happened to remember that she already had problems with her left arm due to an accident. She was due for an MRI the next day and thought that giving the shot in that arm might not be a good idea. The pharmacist agreed, gave it in the right arm. The record didn't. And the special master found out that the PCP's contemporary record confirmed the account. But at least 20 times in the last year, pharmacy, primarily pharmacy chains, record systems, have created a 1 to 3 year delay in a patient becoming compensated for something that should have been handled in about 3 months, just because of carelessness. So when I took dispensing at the University of Washington, our TA in the lab would not allow us credit for any prescription where the label had any errors. She would not allow it. And we'd had to redo the label until it was perfect. One thing I really liked, one thing she said, and especially if you misspell the patient's name, the one thing they know about pharmacy label is how their name should be spelled. If you get that wrong, how are they going to trust anything else you do? At any rate, so the funny part of it is some of you, Phil Ferguson, who spent many years working for Upjohn and later Pharmacia, was an intern at Catterman's Pharmacy. And was an intern at Catterman's Pharmacy. And Don insisted on, any of you know Don would know this, Don insisted on perfect labels. Phil didn't want to admit that he made mistakes on his labels, so he put them in his pocket of his jacket. And one day, Don, who had worked for, I think, Squibb, right? Well, anyway, Don came by and patted his pocket and says, have you thought of going into pharmaceutical sales? Okay. So what? We got a couple of questions on Panda. And the first question, which of the following? It's just the luck of the draw. It's probably because I did not do it right, or it's actually related to genetics. All right, the next question, looks like 100% agreed that, yeah, in this case, if it is to be, it's up to me to get it right. Failure to correctly maintain electronic vaccination record is example of professional negligence, may lead to additional problems. Both of the true, it's no big deal, it so rarely happens. And you might argue with me about whether it's professional negligence, but it's professional negligence. Professional negligence for failing to maintain an accurate record. The Board of Pharmacy, the PQAC, could in fact charge you with violating with unprofessional conduct for failing to properly maintain records. Now, they'd be more likely to do it if it was a pretty common practice in your pharmacy than an occasional error. But it's still a negligent act to get it wrong. Okay. So I'm going to leave you with this last to think about. This is from AccuPack, and I'm not picking on them. They just were the easiest one for me to find some graphics. So this is what they say. We deliver your medications monthly. They're pre-sorted. We deliver your meds. We deliver pharmacy items. You only pay your co-pays. It's free delivery insurance. We keep track of your prescriptions. Say goodbye to the stress and worry from tracking and renewing your prescriptions. We contact your doctor for refills when needed. Okay. So here's the promises. This happens to be from AccuPack, but they've also PillPack and some others do the same, make the same promises. Your meds are delivered in pre-sorted packets. You take the right dose at the right time every time. Is a patient entitled to believe that? Okay. Each month we deliver your medication packets, each month. You don't skip any months. You can skip the pharmacy visits. We'll send you inhalers, creams, devices, misspelled devices, sorry, refrigerated items, OTCs all at once. We keep track of your prescriptions. Say goodbye to the stress and headaches from tracking and renewing your prescriptions. We contact your doctor for refills when needed. Okay. So does that create an implied contract between that pharmacy making those promises and those patients? And can they actually deliver that? So here's the case. I'm not going to go into great depth because it's pretty new. But this patient had cognitive impairment and a history of non-adherence. Her physicians recommended that she go to a particular pharmacy that they knew of that had told those physicians that they were engaged in the process of supplying medications in these daily packages. The physicians provided the pharmacy with a complete list of the patient's meds, and they communicated with the physician to clarify the dosing. And then for two months, one of the meds wasn't in the package. Now, the med that wasn't in the package happened to be kind of a specialty thing. It was an anti-rejection med, and I can't remember which one it was. But it's one that often is dosed, the doses are raised and lowered over time. At any rate, that's probably the reason it got omitted. But the lady didn't recognize it. It also was an oral med, not an injectable. So she ended up with a rejection episode. So the question is for you to think about if you're going to be involved in this. What are you promising your patients? What can you honestly deliver to them? And if you fail to deliver, what do you think the consequences will be? Very quickly on our pre-questions, you probably got all these by now. I think the best answer to this last question is, unless it's really clear to the patient, and I would argue that if you take on a patient who you know has cognitive problems, that you'd better have, if you're going to take on that responsibility, you better have a system in your pharmacy where somebody checks with them, or you arrange for home health care, or somebody else to be there to help them, because you can't promise from a distance to deliver those drugs exactly right. It's a close call as to whether Washington DOH rules actually required the record My reading is that the Department of Health required that the record be given when the administration was given. So yeah, anyway. Well, thank you all so very much for your kind attention. It's been a pleasure.
Thank you for scaring us a bit. Thank you, Bill. Appreciate that. He said that I'd be in trouble if I made it a skunk weed or a skunk flower for him. So I didn't, like I'm in charge of these. It's Lily, Lily.
Oh, okay.
Lily is the code.
Yeah, I told her if she used
session.
skunk flower or stinkweed as the